machine learning was getting to a point where you could use it to automate the review of documents, because there was a big pain point when we had moved from all these boxes of documents when you're producing documents to another side in a litigation. So she's spending hours and hours going through physical papers. We're just converting from that to e-discovery, which is like cloud-based document exchange, which made things easier. And then once that had matured a little bit, we then started to say, we could use machine learning on these e-discovery platforms. A machine learning version of an AI is basically watching what you do, looking at the emails or documents you're saying are relevant or irrelevant, making guesses as to which would be a relevant email that you haven't looked at yet.
Hi, everyone. We have Nathan Walter with us today, who is the co-founder and CEO of Briefpoint, which is this incredible tool designed specifically for lawyers to eliminate the very mundane and time-consuming aspects of law practice, especially those related to document review. Thanks so much for joining us, Nathan.
Hi, happy to be here. Thanks for having me.
All right. So I'm just hoping to jump straight to the discussion, if that's all right with you. So just to start, was curious if you could just tell us about your journey to just develop Briefpoint. Your career has really spanned the legal gamut, right? From working with the LA District Attorney's hardcore gang unit to later shifting into civil law and working in the space of aviation, aerospace litigation. Tell us a little bit about, if you can, the extent to which this informed your and Briefpoint's sort of creation. What was your origin story, so to speak?
That's a great question. I mean, if we want to talk origin stories, I think I've always been into tech loosely and not in a impressive way. I've sort of been a nerdy guy, but I think my first step into actual coding, I think I may have been 10 or 12 years old, and I went to a computer camp. And we were going to build a website. And so I was very young. I would go to computer camps. And I think the first website I ever built was a fan site for the movie Pearl Harbor with Ben Affleck.
Amazing.
Yeah. I mean, it was by all sort of justifications a horrible movie. Like looking back at it, I think it was not a very well-liked movie, but I was a kid and every movie I saw, I just thought it was the best movie ever. So I made a fan site dedicated to that movie. I then sort of went to some other computer camps and stuff. So I always was interested in tech, but I didn't really, my family was attorneys and finance people. And so I never thought that computer science was even an option for me.
Right.
So I went to college for philosophy because I thought philosophy was interesting. And I got out of that major at UC Santa Barbara and realized there was no careers for people to think really hard about Aristotle. And then, so I thought, okay, you know what? I don't know what I want to do. I'll just kick the career decision can down the road. So, okay, I'm just going to go to law school. Cause the law is, I thought it was like, it's very similar to philosophy, but I got really lucky because it turns out I really did love the law because it was everything I loved about philosophy, but had a practical societal impact where instead of asking these questions about what is just and stuff, we say, okay, assuming that this is a just action, how do we incentivize people to act in a just way? Or how do we make a society where innocent people aren't punished for acting innocently and then they don't have to suffer at the hands of bad doers without repercussion? And so that was awesome. And I loved it. And I still studied philosophy in law school. I wanted to be a public defender. So my mom was a public defender up in Napa in California. I thought, I'll just do that. And when you want to be a public defender, it's often advised, okay, join the DA for a bit and learn how the prosecutorial mechanics work so that when you're defending your clients, you can sort of anticipate their moves ahead of time or at least be surprised less often. And I did that at the DA's hardcore gang unit in Los Angeles and just clerked there. And it was just crazy experience. The gore and just, it really changed my opinion, honestly. I had a lot more faith in the justice system, given how difficult it was to put some people in jail that we had video evidence of them committing murders. And it also made me realize that I wasn't strong enough for criminal law because it's so dark. It's so much darker than you can imagine. And I was too weak. I couldn't do it. So I said, okay, I'll go and get a civil litigation job. And so I saw an opening for aviation and aerospace litigation, and I was into technology. And at the time, there was a big boon for drones, and we were in discussions with companies about developing urban air mobility grids, which is like human drone transportation above traffic, car traffic below air traffic. I've sort of, if there's like a thread, I've sort of just done whatever I felt like doing throughout my life, and without regard for an ultimate sort of gain or some sort of external or future state. I never really said, okay, I want to be up here. I want to have this world for myself. So I should do this. And until I started Briefpoint. And I started Briefpoint because as I was practicing litigation, I was on the defense side most often. And I had many cases where I knew that my client had done nothing wrong, should not have paid the other side. But nevertheless, we would negotiate a settlement through mediation that would see the opposing party getting paid hundreds of thousands of dollars because they deserve that money, but because it was cheaper to pay those $100,000 to the other party than it would be for my clients to pay any attorney to prove that they didn't have to pay them that money. And I felt like I wanted to be a public defendant, so I kind of held on to this idea that even in civil law, I'd be surfacing justice to an extent. And in a lot of ways I did. But in this way, I felt not only that I wasn't surfacing justice, I was the tool that was unearthing injustice because of my fees, causing innocent people to pay money that they shouldn't need to pay. Had a really rough mediation one day that kind of broke me, where I really knew that the opposing counsel didn't have a side. He was completely insane. He broke down in tears at one point during the mediation in a professional setting. I mean, he's wearing a suit. You don't cry in a suit. I mean, come on. After that, I said, okay, there's got to be a way to automate this stuff. So I thought, all right, I'm going to teach myself coding and try to figure out a way where I can just automate some of this rote stuff in litigation. So then I can have my client fight longer and, maybe not even getting to trial, but at least hang on to a litigation for a longer period of time so as to incentivize the other side to either, give it up or settle for a much less amount of money because the other side would be, there'd be less attrition there. And that's for plaintiffs and defendants, right? It's like, if you lower the cost of litigation, you increase the access to justice on both plaintiffs and defense side. So I started reading this book, which was like How to Write Python for Dummies. Python's a coding language. And I then graduated from the book to Code Academy courses and all this other stuff and a lot of YouTube videos and just projects and everything. I came across these new AI libraries that this is really interesting because these AI libraries that I discovered at Python that were newer theorized that I might be able to combine those with some AI that was part of like the first legal tech boom in the technology assisted review, which was supervised machine learning that would help you identify relevancy in a document demand. So if I can combine these two AI systems, I could theoretically create a platform that would take data from PDFs of court documents and then rapidly use that data to party information, procedural posture, arguments, causes of action, whatever it happens to be, use that to rapidly construct new documents. And so I created all these vaporware programs, this fake program to see if I had any product that the market would like. And so I started cold calling attorneys one after another, starting at bar number 200,000 in California and going bar number by bar number on the bar's repository, cold calling attorneys, seeing if there was a product. I'm talking for a long time. I apologize.
No, please go for it.
Seeing if there was any sort of product that could emanate from this underlying tech combination that would someone would respond to. And ultimately, I found that what Briefpoint ultimately is today, that was the one that people responded to most. Automated construction of discovery response and discovery request documents. And then I left to my firm to find a team and to really get going with this.
Incredible. No, I think just in general, as you were talking, just makes me wonder, if were I to go on the Wayback Machine right now, do you think I can actually dig up the website that you had?
Oh my gosh. You probably could.
Amazing.
It's so bad. Oh my God.
I mean, if that is what ultimately got us Briefpoint, then I think that is there is significant value in that website then.
Yeah, I'd be shocked if that were true, but I appreciate the compliment.
Right. No, I think that's, again, like a very incredible journey that you've had, as someone, again, like who it has a similar trajectory in terms of entered into philosophy, thought, oh goodness, who is going to really employ me to talk about Aristotle and Rawls all day, and decided, I guess law school is the only place where my skills are somewhat transferable. Very, very much sort of a relatable story. But I think sort of on, this topic of your journey, you've had this incredible long-term presence in the legal tech space. And in many ways, like, you're truly one of the veterans in the field. And I was hoping to go down a little bit of a retrospective on legal tech and law, across the past sort of 2 decades, right? You were there for the first legal tech AI revolution. Now you're really here leading the charge on the second. So I'm really kind of curious to hear your understanding of the differences across the two and how you see that sort of playing.
Sure.
Right.
Yeah, absolutely. And appreciate the compliments again. I will say, legal tech has been around ever since my word perfect. But as far as I have been around for most of the 2 AI booms, certainly this more modern AI boom, but the first AI boom, I was sort of in the middle of it when I left law, when I was actually practicing it in the middle of it. This is in 2016 when supervised machine learning was getting to a point where you could use it to automate the review of documents, because there was a big pain point where you have, we had just, or I guess not recently, but relatively recently, we had moved from all these boxes of documents when you're producing documents to another side in a litigation. And there could be millions of boxes of documents. You have these banker's boxes, you're just going, all these associates spending hours and hours going through physical papers. Yeah. We're just converting from that to e-discovery, which is like cloud-based document exchange, which made things easier. And then once that had, matured a little bit, we then started to say, we could use machine learning on these e-discovery platforms, where basically as you're reviewing these documents, these PDFs, all these things, an AI, which, machine learning version of an AI, is basically watching what you do, looking at the emails or documents you're saying are relevant or irrelevant, then looking at and making guesses as to which would be a relevant email that you haven't looked at yet. And then it shows you that email, you say yes or no, and then it refines all the rest of the data and tries to make best guesses until once you're about halfway through, or 10% through in some cases, it could give you 100 documents, like these are the only relevant documents in this production of 1 million, and I'm 98% certain that they are. And that would save a lot of money, or excuse me, a lot of time. And I used to give talks on this all the time, and it's a lot of the talks in that were very similar to the talks we're having now about AI, in that, there's people, questions of ethics, it's like, well, if an attorney isn't looking at the document, is it really relevant? And how do they know the documents they haven't reviewed are relevant? And, and there was data showing that it was better than attorneys in many cases. I think it was there was actually a study, I forgot the study's name, but this woman I don't even remember the firm, but an AM Law 100 firm conducted this study, and she found that the AI was way better than an attorney. And attorneys were in these conferences. I said, it's the risk of using AI is not what we like. There's greater risk in not using AI, because if you don't use AI and your competition does, your competition will win. And because we're in a capitalistic society where you need to, and I'm not trying to be dramatic, but look, you need to win against your competition. You can't have your competition take all of your clients. If your competition is using AI, they're going to be so much more efficient and better at their job. You're going to lose out to them every time. And I was wrong, because no one adopted TAR. I mean, a lot of, there are some really good applications of technology assisted review. This is TAR, is the name of the document review AI. But the AI, it fizzled out. It fizzled out. And it's hard to say why exactly, but it fizzled out because it was just such a narrow application, I think, and there was still a level of distrust, because at the end of the day, to use this effectively, you would always need to trust that in a document demand, there were documents you didn't see that the AI said, don't worry about it. And you had to trust that a smoking gun email or something wasn't in those documents. And trusting that it was just an issue of trust. And narrow application, trust issues, those two things combined it sort of fizzled out. Now, obviously we have Logical and other e-discovery platforms that use this, but at the time of that boom, it was like what we're seeing right now, where you have all of these different companies trying to give you this stuff, and they all just died out. So now with generative AI, things are different. I mean, they're the same in that we're seeing a lot of companies coming out. We're seeing a lot of obvious uses for it. But instead of really narrow uses where technology-assisted review in the first AI boom was focused on strictly a one workflow in a process of litigation, we're seeing applications everywhere, not even in just in litigation, but in contracting. We're seeing a lot more public awareness about this. So, every in-house counsel team knows about generative AI and large language models and transformers and ChatGPT. They know about that now. So now your clients already know about this AI, whereas in the first boom, the clients of in-house counsels, people, they had no idea. And so now there's more of a market expectation for this automation, and it's just the applications are obvious. It's the opposite of the Web3 boom where we had crypto and they're like, I have all these solutions. And then it's like, well, where are the problems? And, and here it's like, wow, we have all these solutions to all of these problems. And so it's very different, and it's going to be more long lasting, and it's way bigger, but it's way bigger than any AI boom we've ever been in. And it is still yet not as big as, it is as big, but it's not as big as some people expect it to be.
Okay.
And that's something, we can talk about, but this is meaningfully different. There's never been anything like this. There's never been more money in the legal technology space ever. We have a $650 million acquisitions happening with Thomson Reuters. We got Reveal acquiring Logical. There's been more M&A moves in legal tech in the last year than there ever have been. And it's a crazy market. I mean, from a raising perspective, if I want to put on my entrepreneurship hat, there is a complete drought of money for startups, unless you're a legal tech AI company, basically. I mean, it's still not ideal, but it's crazy that the markets are focused so much on this when they never have been before. And the reason is the obvious use cases of generative large language models.
Absolutely. I have some questions more about the sort of the history of these booms, but I think just to take a comment that you mentioned, just about the sort of, everybody knows about it, but there's issue of trust. I was wondering if you could expand on that a little bit more, because we have, let's say, like Sam Altman being marched out in front of Congress to tell us like, no, things are going to be okay. Whereas like how much of that convincing do you think has trickled down onto, let's say, law firms or judges, where like I can imagine scenarios in which, let's say, maybe a skeptical judge sees that or knows that a brief that came up to them was in some ways AI assisted. Do you think there is a presumption of, do you think there's a negative presumption that is in perhaps the judge's head as they go to review it? Or do you think any of that, I don't want to say prejudice, but negative connotations relating to AI usage has not trickled too far into the legal space? I'm just wondering what the perception currently might be.
Yeah, the trust I see is the trust issues are inherently the same as they were with the AI document review systems were. Namely, when you're using AI to draft a brief and create legal arguments and you're not checking those legal arguments, it would be the same as you producing a production of documents without reviewing every document, in that you're not confirming things. And as an attorney, you need to make sure things are accurate, whether your paralegal's drafting and giving it to you, or whether you're citing a case with a yellow flag on Westlaw and you need to, it's not a red flag, but like it's still a yellow. You should still probably look at that. That being said, the difference between the trust issues we're having then and we're having now is that now the trust issues can be alleviated if people understood how these things worked and used them properly. So the way the transformer works, a transformer is the model. It was invented by Google in this paper published called Attention is All You Need. Transformer is what ChatGPT is, and the large language model, generative AI, we're talking about transformers. And the way it works is just like when you're typing in Google and there's an autocomplete. So if you type in Google, it says, when is the first space? And then there's a drop-down menu and it says, day of Lent, and there's a series, a list of possible next words. ranked from most likely given your search history to least likely given your search history.
Right.
So it generates words one word at a time based on two things. Number one, statistical probability, and then they weigh that probability. They compare that probability to, in the context of Google searches, your search history, geography, and some other data points. So we have statistical probability, and then we have weights and balances that are that take it. Because if it was statistical probability, then there's so many people in India and Asia, and if they were all using Google, then and there's just so many more people using Google over there. If you're in Puerto Rico and you're asking a question, it's always going to autofill answers that are relevant to a different country, right? So they need to look at your geographic location, and they need to look at your search history in order to provide you autofills that are catered towards your needs, so you get better search results, right? So in the large language model context, the weights and balances are not your search history or your things, but when you write a question and then it gives you an answer, it looks at your question and it generates an answer or a response based on what similar questions and similar responses have received thumbs up by people saying, okay, you did a good job, AI, or I like this response to this question. And they've given ChatGPT millions and maybe even 1 billion of these data points saying good responses to these questions look like this. And that's what it's generating. And so I make that sort of technical classification to stress that if it gives you a case citation, it's always going to look good. It's designed to hijack our psychology into giving it thumbs up feedback, not to give us the truth or an accurate citation. So if you understand how a transformer works, there should be no trust issues because you shouldn't be trusting it to generate case citations or tell you the facts of a case when it doesn't have access to it. Those things are always going to beget hallucination because that is what it's designed to do. It's designed to give you text. Now, the trick is when using these things is that you can use these things to great effect without relying on it generating anything by restricting its generative ability to data that you feed it. So, for example, if you have case text by co-counsel, they don't generate it. It is a generative AI that gives you citations. It's not actually generating those citations, though. Instead, when you ask it a legal question, it analyzes your question and says, okay, this must be a question about an auto tort and someone drinking under the influence. Well, they have those tags, and then they, Pablo and Jake and all the team over there, they've created this huge repository of codes that link certain sentiments to certain citations. So it's okay, this is a California user asking about the evidentiary or penal code statutes for speeding while intoxicated. That's code CAPITDWI. And then they get that code, and then from their giant repository, they convert that into a citation to an actual case. So that is a long way of saying you can use generative AI to great effect when you combine it with reliable data, when you're tying its generative ability to a repository of truth in the context of data that's real. So you're asking about a real case and you're saying, hey, here's some information, and it uses that information to go to other truth information, then it can be very powerful and you get a lot of good effects.
Right, absolutely. Well, I think I think at this point I'm convinced. I think, at least for someone who is very, very non-technical, I think your explanation was not only sort of understandable to me, but also quite persuasive, right? In terms of helping me understand, this is actually the fundamental mechanics of what's going on, and that I should place my faith in a sort of well-constructed, well-fed in some ways, AI system. But I think with that said, I am kind of curious about, how it seems like part of this can be an education issue, or we need to teach people how they work, how to use them properly. But if we're also throwing around these words like statistical probability, weights and balances, transformers, do we have a risk of, scaring off some current lawyers, future law students? How, you're someone who is very, very technically oriented, as someone who was, or is a lawyer. How do we teach folks how to, let's say, write a prompt such that they actually get the answer that they want? Like, is there a teaching mechanism here, or what might we be able to do?
Yeah, I mean, I'm sure there is a teacher, but it boils down to me not being a good teacher because I'm too in the weeds. And I think that's sort of you have to really understand something really, really well to teach it in a way where it's understandable, because you have to like reduce it to metaphors or analogies. And in order to ensure that those are actually applicable and not reductionist, you actually have to have a very deep understanding of it. So I think it boils down to our ability to teach, which hopefully is just a matter of time where people like me will learn how to, use less unnecessarily complicated terms, because I'm sure there's better ways to explain it. So there's a teaching thing. And the other thing is like, you don't need to, if you understand how it works, and you shouldn't use ChatGPT for anything, really. I mean, you can use it for things, but what you should look for are applications that are built on top of GPT-4 or ChatGPT that have reliable data sources and that are using that. Unlike the first AI wave, where in order to check your work, you'd actually have to go through every single document the AI decided wasn't relevant. Checking your work with generative AI today, or the AI wave now, is incredibly easy, because it gives you if it gives you a case citation in case text, you can check it. Well, guess what? Case text will actually give you a link, likely, where you can check it right then and there. So it's really easy to check your work here, which is a really good a really good benefit. And I think you should, and you should check it in the same way you check an associate's work. In the case with the attorney citing hallucinated citations, I obviously thought, well, that's on him. I mean, you can't go to court, to a hearing, and the judge says, hey, you cited all these BS cases. You can't go, oh, you know what? My associate did that. Sorry, Judge. We're all good though, right? No, you're not all good. It's on you. And I think it's the same with generative AI. The issue is that with generative AI, it's much better at giving you citations that look good, whereas associates don't have that ability. So it's easier to catch associate errors, because there's probably spelling errors. It might be a formatting thing that in the first few pages of a document take you off to be like, okay, I need to read every word of this brief. This guy has no idea what they're doing, or whatever it happens to be.
Great. No, thank you so much for sharing that, Nathan. I think that's really, really helpful to know. And then also, I think, gives me some optimism in terms of where sort of all of this is headed, especially when it comes to both the learning and the trust sort of, I don't want to say conundrums, but issues. And I think you've really given us such rich information relating to the differences in terms of the legal tech side of things, in terms of how they're perceiving both the first and the second sort of AI boom. I'm really kind of curious to hear a little bit more about the more core legal side of things, right? Like, we've started to see the courts try to flesh out the beginnings of some sort of doctrine relating to legal tech regulation, as well as the use of AI technologies in law. And you've written extensively on this issue yourself. I was just wondering if you could speak a little bit about that, like where you see that evolution going, the demarcation of what constitutes lawyering versus what constitutes just an automated process that lacks a creative component and places it outside of the act of law, or the art of law, whatever that might be.
Yeah, I mean, the courts. I mean, we could talk about the good, bad, and the ugly. Like, the bad and the ugly are those court orders that state, if you used AI to prepare a document, you need to state that. That statement, and that's almost a direct quote from some court orders where they're requiring people to do that. That is really, it's just poorly phrased, because AI, everyone knows AI is a generic term. Maybe they don't, but AI is a generic term for different types of effectively machine learning. And, before, when would ChatGPT come out? Like 2022? Before 2022, AI meant unsupervised machine learning, or, neural networks. It meant machine learning, right? And after ChatGPT, now AI means generative AI with large language model transformers, right? So it's like in the course of 2 months, what we were referencing in society when we uttered the words AI were tied to one thing, and then after 2022, now it's tied to something else. And the problem is, so you can't say, okay, no AI, because if you use AI in everything you do, if you Google your client's or the court's address in order to insert the address on a document, then you would need to report that to the court, because Google uses AI under that broad definition. But even if Google said, or excuse me, even if the judge said, okay, no generative AI. Well, generative AI is if we're talking about transformers, that's used in Google as well. If you press tab to auto complete the court name to find it, then that's generative AI. And I think what they're trying to do is say, okay, if you use something like ChatGPT, a large language model, generative AI transformer, in order to generate meaningful text onto your document, then you need to report it. But now we have the question, if we even did that, then it's like, okay, what's meaningful, what's not? Because certainly if you use the generative AI to find the judge's name, a Google search, and you found the judge's name and their division through Google, is the insertion of the judge name and the division onto your caption page in your document meaningful? Well, if you don't have it, in some courts, they're not going to accept your document. So it's meaningful there. And we get into this mess. And I think that we were already good with the regular rules of ethics that would punish an attorney for serving a bad document to a court because they didn't review the document when one of their associates or paralegals drafted the document. I think those rules of ethics are completely adequate as they are. It's the attorney's duty to ensure that what they put into the court is honest, truthful, and representative of the common law that they cite. And that's a bad thing. On the good side of things, we go back to Skadden in 2015, which was a case where basically the court in dicta stated that it was a dispute on like fees or something, and they were trying to determine what constituted the practice of law. And there was someone in that case that used an AI to, I believe it was review documents, but they used some sort of machine to execute a rote task. And one side was arguing that was a practice of law, the other wasn't. And the judge said, if a machine can do it equally as well as an attorney, then that's not the practice of law. And I think that there's a lot about that statement that's true. Because when you go to law school, you learn how to practice law, right? I mean, it's not as practical, but like you learn how to be an attorney. You learn how to think like an attorney. And so when you're thinking about AI systems and you're thinking about using them, I think the best uses of AI should be those that target those tasks that don't really require the brain power of an attorney, like tasks that almost look like if they're copy and paste jobs, if it's sifting through documents, if it's writing out a caption page and inserting party names into a template, or looking through old work product and copying and pasting statements of law or causes of actions into a new complaint or document. That's not really requiring a legal analysis. What does require legal analysis? Well, it's going to be deciding which arguments to pull into your new brief. It's going to be drafting the facts and the lights most favorable for your client. It's going to be communicating with your client in order to elucidate or get those facts. And basically, if you're using AI and it's automating so much where you are redundant as an attorney, you're not using AI properly. Because you're trusting it too much. Trust AI to do the things that don't require your skills, your years of experience, that don't require a holistic understanding of the needs of the client, the facts of the case, the temperament of the judge, the laws of the court and the jurisdiction you're in. That holistic understanding of a litigation and the environment of a litigation, there are many tasks that require that insight. Those tasks should never be automated by an AI. That's too much data to feed an AI system in order for it to rely on, in order for you to rely on it really with a straight face. However, there's so many tasks around that can be automated those are the tasks you're doing. So I always tell people, if you're using, if what you want AI to do for you, if AI could do that, would it make you redundant? And if it would make you redundant, then you should not do that with AI, because there's real value in practicing litigation and like being a practitioner that goes beyond pure regurgitation of prior work product into new documents and other things like that, which really should be automated.
Right. Right. No, that makes sense. No, thanks so much, Nathan. I think just you walking us through really what the changes have been in the legal tech and the law space across the past 2 years. Incredibly, like just a rich history. So thank you so much sort of for giving us all of that. I think just as a last question, I'm just kind of curious, if you could chat a little bit about what the future holds, in general, like both for Briefpoint in particular, but just for legal tech in general, right? It sounds like Briefpoint has had a monumental success in recent days, excuse me. If you wouldn't mind just like telling us a little bit about that. Do you where is your company and yourself heading? Where do you see the space in general sort of moving toward in the next year or 5 years?
Oh, definitely. I mean, I'm an optimist. And so my goal with Briefpoint and my hope for the future is we create a world of the practice of litigation where all an attorney needs to do to be like a great attorney is understand, be an empathetic counsel to the client, understand the needs of their client, and then use that understanding in order to zealously represent them by just coming up with creative arguments, creative solutions, effective counsel solutions, being incredibly strategic, being more of a high, what do you call that? The high ideas. I forget it's not coming to me, but basically like being the captain of the ship and not the captain and every employee on that ship at the same time.
Right.
And I think that's a world that AI can build. And that's what Briefpoint's trying to build, where you don't need to make massive personal sacrifices in order to maintain competency as a litigator. You don't need to spend all night, redrafting a statement of facts or undisputed facts or motion for summary judgment. Instead, you can focus on the most impactful parts of your job, like drafting a legal analysis, conducting depositions, trial prep, et cetera. And then that's all you have to do. So you work less, but the work that you do is so much more meaningful. And then your attention to detail that you invest into these tasks are more fruitful because you're getting way more bang for your buck for every minute you're spending working on something. If that work is the work that's moving the needle, you're getting so much more out of your energy. And I think that's going to make a greater quality of life for litigators. And we're going to see a lot less burnout because all these people, we're going back to the good old days before email, where you'll have more capacity and you can take your time. And yes, obviously, with the new advent of the email, that's sort of what everyone said would happen. But then expectations just rose to meet the market. But even now, I mean, if expectations rise and you're just conducting higher quality work more frequently, I think that's a net positive overall. As far as the market goes, I mean, we're going to see a lot of really great solutions coming out. I think the solutions that are going to be easy to use and that work out of the box are going to win out. I think people are getting tired of long implementation times with tech products, and where you have to say, oh, this one tech product says, oh, we're the most easy to use tech product,
right?
And then you sign up, they're like, okay, so it's going to cost us $4,000 to train you how to use our product. I see that those products going away, and the simple, easy to use, user-centric design products coming to market, and because they can really offer generative AI mixed with reliable data in a way that doesn't require technical ability.
Absolutely. But then what about Briefpoint in particular, if you don't mind sort of chatting a little bit about that, about your recent successes, where, you are heading?
Sure. So Briefpoint, we are an out-of-the-box solution that drafts discovery response and discovery request documents. So you can draft 70 pages of content that requires no red line within the first few minutes of your first sign-in. And if I'm not going to sell it here necessarily, you can just go to briefpoint.com or briefpoint.ai and try it yourself. But the goal for Briefpoint is to basically automate the entirety of litigation to an extent where all a litigator needs to do in the context of document preparation is draft the parts of the document that have the greatest impact, namely statement of facts and legal analysis. And which is a large part of the document, sure, but every other part of the document, like statements of law and everything, all the boilerplate stuff, we seek to automate all of that out of the box so that all you need to worry about when you're drafting is the things that you went to law school to draft, the interesting.
Right. No, that's pretty incredible. I think a lot of what you just mentioned about Briefpoint, it sounds like very much in line with the general philosophy you've articulated earlier. Like you're really practicing what you preach in many ways of, where building a system to complement you as an attorney, not to supplement, your work, not to sort of intrude into that space. But yeah, I think just in general, thank you so much, Nathan, for taking the time to chat. Really appreciate you taking the time for this conversation. I'm personally leaving this discussion with a much more optimistic view of where we're heading, which I think is a great thing. But really just best of luck to you. Very, very excited to see Briefpoint, develop and then just, thrive in the coming years. Really, really appreciate it. Thank you, Nathan.
Thank you so much. It's been a pleasure.
The practice of law is changing, and we're here for it. Thank you so much for tuning in to today's episode of Transforming Legal Ops. Follow us for more insightful conversations about the transformative impact of legal tech. And follow Speed Legal and let us know in your comments and messages about how you personally leverage legal tech to make your own work more efficient. See you next time.